Many people prepare for family court by imagining one dramatic moment where they tell the judge everything. A hearing is usually more structured than that. There may be a docket call, announcements, agreements, questions from the judge, testimony, exhibits, and a ruling or later written order. The exact sequence depends on the court and the type of hearing. This episode gives you a practical way to prepare for the sequence without pretending there is one national family court script. This is educational information, not legal advice. Start with the hearing notice and the papers that brought the matter before the judge. Write down the court, case number, hearing date, time, department or courtroom, appearance method, and the exact request or response being heard. A status conference, temporary orders hearing, enforcement matter, modification request, and trial can have very different purposes. Do not prepare for a trial if the notice is for a short procedural hearing. Use the official notice and current court instructions as your source of truth. If you are appearing in person, plan for parking, security, a walk to the courtroom, and the possibility that the docket is running late. Some court guidance recommends arriving early enough to get through security and find the courtroom. If you are appearing remotely, test the connection, camera, microphone, display name, and document access ahead of time. Keep the notice, case number, and contact information for the court or coordinator available. Check-in procedures vary. You may need to speak with a clerk, bailiff, courtroom coordinator, or other staff member. Be polite and ask process questions without arguing the facts in the hallway or chat window. When the court begins, there may be instructions about phones, recording, witnesses, interpreters, or how cases will be called. Your case may not be heard immediately. Listen for your name and case number. When your case is called, be ready to identify yourself, your role in the case, and whether you are ready to proceed if the judge asks. If you need an interpreter, accommodation, or more time, the safest approach is to request it through the court's current process as early as possible. Do not wait until the judge is already moving through the hearing if the need was reasonably foreseeable. A useful opening is short. State what the hearing is about, the decision or response you are asking the court to consider, and the 2 or 3 facts that explain why. Do not start with every painful detail in the relationship. A judge may need to interrupt or redirect you because the court has a particular issue to decide. A short opening gives you a reference point. This is the issue, these are the facts, and this is the practical result I am asking about. Then let the process move to evidence, questions, or testimony. Keep your evidence organized so you can identify each document quickly. Depending on the court's rules, documents may need to be filed and served before the hearing. A witness statement, declaration, or live testimony may be treated differently. A written message is not automatically self-proving just because it is printed. If you need to use an exhibit, follow the judge's instructions and provide the required copies. If a witness has personal knowledge, prepare questions that establish who they are, what they personally observed, when they observed it, and why it relates to the issue. Avoid asking a witness to repeat speculation or conclusions they cannot support. Your preparation should include a listening page. Write down the statement, the document, or fact that relates to it, and whether you need to respond now or later. Do not interrupt. If you do not understand a question, ask for it to be repeated. If you do not know, say that you do not know rather than guessing. If the other party raises a new issue, ask whether the court wants you to address it and follow the judge's direction. A calm, note-taking system is often more useful than trying to rebut every sentence in real time. The hearing may end with a ruling, a later decision, or instructions for a written order. Before leaving, write down every deadline, document, payment, class, exchange term, or follow-up the judge mentions. A spoken ruling and a signed filed order are not always the same practical document. Find out who is responsible for preparing the order, whether the judge must sign it, and how you obtain a filed or certified copy. If you do not understand the result, ask the clerk or a qualified local resource about the process for obtaining the written order. Do not rely on memory after an emotional hearing. Your final prep page should have 5 blocks: hearing purpose, opening explanation, fact timeline, exhibit and witness list, and follow-up deadlines. Add a logistics box for arrival or remote access. Rehearse the opening out loud, but do not memorize a speech that prevents you from answering the judge's question. If the matter involves safety, violence, a protection order, a contested custody change, or a possible loss of housing or contact, seek qualified local help as soon as you can. Review the child custody hearing roadmap at practicalcourtprep.com for a structured organization aid, then verify the current rules for your court. Download the child custody hearing roadmap at practicalcourtprep.com. Educational information, not legal advice. Verify current local requirements.